Namaste students. Today's our topic is horizontal agreements. Horizontal agreements covered under the competition law. It will deal with the basics of horizontal agreements, types of such agreements, reasons for pollution by businesses and regulation of such agreements by the competition authority. It will also cover horizontal agreements like market allocation, controlling production and bid pricing. The module will also discuss catalyzation and the ways to detect and prevent catalyzation. Competition law is an economic law and thus an understanding of various market structures like monopoly and oligopoly will help readers better understand the reasons for businesses colluding to gain market power. Basic knowledge about microeconomics will also help in appreciating the adverse effects the horizontal anti-competitive agreements can have on economy and consumers and the reasons for regulating such conduct. Objective: after reading the module, the readers will be able to appreciate as to why the anti-competitive effects of the horizontal agreements and practices need to be regulated by the competition law. Further, the readers will learn regarding the different type of horizontal agreements. A reader will realize as to why cartels, which are a form of horizontal agreements, are given esteem treatment under the competition law worldwide. Further, the reader will also understand as to why there is more international governance and consensus in dealing with hardcore cartels which have anti-competitive effects on consumer across the borders. Broadly, for the purpose of the competition law, agreements between the market players may be classified as either horizontal or vertical. Horizontal agreements occur between the enterprises at the same level and have potential to adversely affect the competition if intended to do so. Cartels are one form of the horizontal agreements which, due to their pervasive effects on the competition, consumers and the economy, are the focus of the enforcement domain of the competition authorities worldwide. Thus, this module, the readers are expected to learn definition and nature of horizontal agreements, types of horizontal agreements, cartel, bid pricing, price fixing agreements, detecting cartels, licensing program to detail cartel, agreement in restraint of trade. A restraint of trade is simply some kind of agreed provision that is designed to restrain another trade or property agreements that run counter to public policy. Unless the resemblance of an agreement could be shown, one of the earliest instances of trade restraints has been recorded in the English common law system in the doctrine of restraint of trade, which become the procedure to modern competition law. There is always a possibility that market players can coordinate their action to achieve a position so that they can indulge in anti-competitive practices. Thus, the firms can collude and control production and raise prices. Collusion can be defined as a situation where firms coordinate their action to reach anti-competitive outcomes and gain higher profits. Collusion can be explicit or tacit. Some anti-competitive agreements may be open, but most are secret